The single question of law therefore presented in this case is whether a landlord, who, without any express covenant as to delivery of possession leases property to a tenant, is required under the law to oust trespassers and wrongdoers so as to have it open for entry by the tenant at the beginning of the term, that is, whether without an express covenant there is nevertheless an implied covenant to deliver possession. It seems to be perfectly well settled that there is an implied covenant in such cases on the part of the landlord to assure to the tenant the legal right of possession, that is, that at the beginning of the term there shall be no legal obstacle to the tenant's right of possession. This is not the question presented. Nor need we discuss in this case the rights of the parties in case a tenant rightfully in possession under the title of his landlord is thereafter disturbed by some wrongdoer. In such case the tenant must protect himself from trespassers, and there is no obligation on the landlord to assure his quiet enjoyment of his term as against wrongdoers or intruders. Of course, the landlord assures to the tenant quiet possession as against all who. Chapter 8, Leasing Real Property 215. Rightfully claim through or under the landlord. The discussion then is limited to the precise legal duty of the landlord in the absence of an express covenant, in case a former tenant, who wrongfully holds over, illegally, refuses to surrender possession to the new tenant. This is a question about which there is a hopeless conflict of the authorities. It is generally claimed that the weight of the authority favors the particular view contended for. There are, however, no scales upon which we can weigh the authorities. In numbers and respectability they may be quite equally balanced. It is then a question about which no one should be dogmatic, but all should seek for that rule which is supported by the better reason. It is conceded by all that the two rules, one called the English rule, which implies a covenant requiring the lessor to put the lessee in possession, and that called the American rule, which recognizes the lessee's legal right to possession, but implies no such duty upon the lessor as against wrongdoers, are irreconcilable. The English rule is that in the absence of stipulations to the contrary, there is in every lease an implied covenant on the part of the landlord that the premises shall be open to entry by the tenant at the time fixed by the lease for the beginning of his term. A case which supports the English rule is Happle-Sheema v. Christopher, 76 NEB 352, 107. NW 382, 111 NW 359, 9 LI. NS, 1127, 14 An. Cass. 399, note. In that case the court gave these as its reasons for following the English rule. We think that the English rule is most in consonance with good conscience, sound principle, and fair dealing. Can it be supposed that the plaintiff in this case would have entered into the lease if he had known at the time that he could not obtain possession on the 1st of March, but that he would be compelled to begin a lawsuit, await the law's delays, and follow the case through its devious turnings to an end before he could hope to obtain possession of the land he had leased? Most assuredly not. It is unreasonable to suppose that a man would knowingly contract for a lawsuit, or take the chance of one, whether or not a tenant in possession intends to hold over or assert a right to future term may nearly always be known to the landlord, and is certainly much more apt to be property 216 within his knowledge than within that of the prospective tenant. Moreover, since in an action to recover possession against a tenant holding over, the lessee would be compelled largely to rely upon the lessor's testimony in regard to the facts of the claim to hold over by the wrongdoer, it is more reasonable and proper to place the burden upon the person within whose knowledge the facts are most apt to lie. We are convinced, therefore, that the better reason lies with the courts following the English doctrine, and we therefore adopt it, and hold that, ordinarily, the lessor impliedly covenants with the lessee that the premises leased shall be open to entry by him at the time fixed in the lease as the beginning of the term. So let us not lose sight of the fact that under the English rule a covenant which might have been but was not made is nevertheless implied by the court, though it is manifest that each of the parties might have provided for that and for every other possible contingency relating to possession by having express covenants which would unquestionably have protected both. Referring then to the American rule, under that rule, in such cases, the landlord is not bound to put the tenant into actual possession, but is bound only to put him in legal possession, so that no obstacle in the form of superior right of possession will be interposed to prevent the tenant from obtaining actual possession of the demised premises. If the landlord gives the tenant a right of possession, he has done all that he is required to do by the terms of an ordinary lease, and the tenant assumes the burden of enforcing such right of possession as against all persons wrongfully in possession, whether they be trespassers or former tenants wrongfully holding over. So that, under the American rule, where the new tenant fails to obtain possession of the premises only because a former tenant wrongfully holds over, his remedy is against such wrongdoer and not against the landlord, this because the landlord has not covenanted against the wrongful acts of another and should not be held responsible for such a tort unless he has expressly so contracted. This accords with the general rule as to other wrongdoers, whereas the English rule appears to create a specific exception against lessors. It does not occur to us now that there is any other instance in which one clearly without fault is held responsible for the independent tort of another in which he has neither participated nor concurred and whose misdoings he cannot. Chapter 8, Leasing Real Property 217. Control. For the reasons which have been so well stated by those who have enforced the American rule, our judgment is that there is no error in the judgment complained of. Affirmed. Notes and questions. 1. The basic law. U.S. jurisdictions remain split over the landlord's duty to provide possession. A majority of jurisdictions, and the Uniform Residential Landlord and Tenant Act, now follow the English rule, but the American rule remains alive and well. As should be obvious, the biggest difference between the two approaches is the remedy available to the dispossessed tenant. Under the English view, the tenant may terminate the lease and sue the landlord for damages. The tenant can also choose to withhold payment from the landlord until the tenant is able to take possession. In contrast, under the American rule, the tenant must bring an eviction action directly against the holdover. 2. Justifying the rules. What policies support the English view? What policies support the American view? Would you find the remedies available under the American rule helpful? 3. Conceptual arguments. The Hanan case does an excellent job discussing the policy rationales for and against the two rules. But what about the more conceptual arguments? If we view the lease as a conveyance of the legal right to possession, isn't the American rule correct? Once a landlord turns over possessory rights, aren't her obligations fulfilled? 4. What do tenants know? Do you think that tenants in American rule jurisdictions know that their landlord has no obligation to provide them with actual possession? Should that matter? 5. What rules are mandatory? Imagine that you sit in a state legislature that wants to adopt the English rule by statute. Should you make the new law a mandatory rule or a default position that parties can negotiate around? Property 218. 6. Your lease. Does the lease for the apartment you're currently renting make any provision for this problem? 4. Tenant selection. As we saw earlier in the textbook, the right to exclude remains a cornerstone of property ownership. Owners have expansive power to keep others off of their land and out of their homes. Generally speaking, this right extends to landlords, who have broad discretion to select tenants as they see fit. Landlords, for example, remain free to exclude smokers from their properties. They can also refuse to rent to a tenant who acts erratically, possesses a criminal record, or has a low credit score. Landlords, however, cannot violate state or federal anti-discrimination laws when they go through the leasing process. The Civil Rights Act of 1866, one of the oldest laws that protects tenants against discrimination in the housing market, is the Civil Rights Act of 1866. Passed in the aftermath of the Civil War, the Civil Rights Act of 1866 prohibits all discrimination based on race in the purchase or rental of real or personal property. See Jones v. Alfred H. Meyer Company, 392 U.S. 409, 1968. Thus, landlords cannot deny an apartment unit to a potential tenant based on tenant's heritage or the color of their skin. There are no exceptions. The Fair Housing Act of 1968. The Fair Housing Act of 1968, and its many amendments, greatly expanded the number of individuals covered by anti-discrimination law. Broadly speaking, the Fair Housing Act, FHA, prohibits discrimination in the renting, selling, advertising, or financing of real estate on the basis of race, color, national origin, religion, sex, familial status, and disability. It is worth looking closely at some of its provisions. The Act begins with a statement of policy and a few counterintuitive definitions. Chapter 8, Leasing Real Property 219. 3601. Declaration of Policy. It is the policy of the United States to provide, within constitutional limitations, for fair housing throughout the United States. 3602. Definitions. As used in this subchapter. C. Family includes a single individual. H. Handicap means, with respect to a person, 1. A physical or mental impairment which substantially limits one or more of such person's major life activities. 2. A record of having such an impairment, or 3. Being regarded as having such an impairment, but such term does not include current, illegal use of or addiction to a controlled substance, as defined in Section 802 of Title 21. K. Familial status means one or more individuals, who have not attained the age of 18 years, being domiciled with 1. A parent or another person having legal custody of such individual or individuals, or 2. The designee of such parent or other person having such custody, with the written permission of such parent or other person. The protections afforded against discrimination on the basis of familial status shall apply to any person who is pregnant or is in the process of securing legal custody of any individual who has not attained the age of 18 years. The definition of familial status surprises many students. Whom, exactly, does it protect? Unmarried people. Single mothers. Although more intuitive, the definition of handicap has generated a number of legal disputes. Alcohol, for example, is not a controlled substance under Section 802 of Title 21. Does that mean that a landlord cannot refuse to rent to a person who drinks heavily or sounds very drunk and belligerent over the phone? The real meat of the Fair Housing Act comes in 3604. The first subsection makes it unlawful to refuse to sell or rent, or otherwise make unavailable a dwelling to any person because of race, color, religion, sex, familial status, or national origin. C. 42. USC 3604a. Later sections provide similar protections for the handicapped. The Property 220 Act then takes a number of additional steps designed to eliminate discrimination from the housing market. Under the terms of the law, it is illegal to 1. Discriminate in the terms or conditions of a sale or rental, 3604, b. 2. Create or publish an advertisement or statement that express a preference or hostility toward individuals in any of the protected categories, 3604, c. 3. Lie about or misrepresent the availability of housing, 3604, d. 4. Refuse to permit handicapped tenants from making reasonable modifications of the existing premise at their own expense, 3604, f. 3. 5. Refuse to make reasonable accommodations in rules and policies to accommodate individuals with handicaps, 3604, f. 3. b. 6. Harass or intimidate persons in their enjoyment of a dwelling, 3617. Unlike the Civil Rights Act of 1866, the Fair Housing Act does contain a number of important exemptions. Section 3607, b, for example, allows housing designated for older persons to bar families with young children. Similarly, Section 3607, a, allows religious organizations and private clubs to give preferences to their own members. The most controversial exemption, reproduced below, is the so-called Mrs. Murphy exemption. B. Nothing in Section 3604 of this title, other than subsection C, shall apply to 1. Any single-family house sold or rented by an owner, provided that such private individual owner does not own more than 3 such single-family houses at any one time, provided further, that in the case of the sale of any such single-family house by a private individual owner not residing in such house at the time of such sale, or who was not the most recent resident of such house prior to such sale, the exemption granted by this subsection shall apply only with respect to one such sale within any 24-month period, provided further, that such bona fide private individual owner does not own any interest in, nor is there owned or reserved on his behalf, under any express or voluntary agreement, title to or any right to all or a portion of the proceeds from the sale or rental of more than 3 such single-family houses at any one time, provided further, that after the 31st of December 1969, the sale or rental of any such single-family house shall be excepted from the application of this subchapter, only if such house is sold or rented, without the use in any manner of the sales or. Chapter 8, Leasing Real Property 221. rental facilities or the sales or rental services of any real estate broker, agent, or salesman, or of such facilities or services of any person in the business of selling or renting dwellings, or of any employee or agent of any such broker, agent, salesman, or person. And b. Without the publication, posting or mailing, after notice, of any advertisement or written notice in violation of Section 3604 c. of this title, but nothing in this proviso shall prohibit the use of attorneys, escrow agents, abstractors, title companies, and other such professional assistants as necessary to perfect or transfer the title, or 2. Rooms or units in dwellings containing living quarters occupied or intended to be occupied by no more than 4 families living independently of each other, if the owner actually maintains and occupies one of such living quarters as his residence. What does this exemption allow? If the act is intended to root out pernicious discrimination, why include this provision? It is crucial to note that the plain text of the Mrs. Murphy exemption states that it does not apply to 3604 c, the subsection that prohibits discriminatory advertising. Thus, although certain categories of landlords are exempted from the statute's basic framework, they are still not allowed to post discriminatory advertisements. State anti-discrimination efforts. Some state legislatures have passed laws that afford far more protection from discrimination than the federal statutes provide. Minnesota, for example, protects against housing discrimination on the basis of sexual orientation, gender identity, marital status, and source of income. Other states in the Northeast and West Coast provide similar coverage, but these positions are in no way a majority. As the map below indicates, in most states nothing prevents a landlord from denying an apartment to an engaged heterosexual couple, based on the belief that cohabitation before marriage is sinful. Property 222. Proving discrimination. 2 broad categories of cases may be brought under the FHA: disparate treatment claims and disparate impact claims. A sign erected by white homeowners trying to prevent black tenants from moving into their Detroit neighborhood, 1942. Chapter 8, Leasing Real Property 223. Disparate treatment claims target intentional forms of discrimination, including the refusal to rent based on one of the protected categories. A plaintiff can show intent to discriminate with smoking gun-style evidence, such as statements by the landlord that he would never rent to an Irishman. Of course, modern landlords rarely make such forthright admissions. As a result, courts in the United States have established a burden-shifting approach that allows plaintiffs to prove intentional discrimination with indirect circumstantial evidence. The initial burden is on the plaintiff to make a prima facie case of discrimination. In a refusal to rent case, the plaintiff must show that 1. That she is a member of a class protected by the FHA, 2. That she applied for and was qualified to rent the unit, 3. That she was rejected, and 4. The unit remained unrented. Once the plaintiff has established sufficient evidence to state a prima facie case, the burden shifts to the defendant landlord to proffer a legitimate non-discriminatory reason for the refusal to rent. If the defendant meets this requirement, the burden then shifts back to the tenant to prove that the reason offered is a pretext. Discrimination is often ferreted out through the use of testers. Advocacy groups, many of which are funded by the federal government, will send comparable white and black individuals to inquire about renting a vacant unit. If the landlord treats the testers differently, for example, provides different levels of assistance, shows different units, provides different information about unit availability, this provides persuasive evidence of illegal discrimination. Disparate impact claims allege that some seemingly neutral policy has a disproportionately harmful effect on members of a group protected by the FHA. These cases rely heavily on statistical evidence and employ a very similar burden shifting methodology as the disparate treatment claims. Using statistics, plaintiffs need to show that a defendant's policy has actually caused some disparity. The defendant then has the opportunity to escape liability if it can show that its actions are necessary to achieve a valid goal. See Texas Department of Housing and Community Affairs v. Inclusive Communities Project, Inc., 135 SCT 2507, 2015. Problems. 1. William Nithamer, who is gay and HIV positive, attempted to rent an apartment from Brenneman Properties. Nithamer did not reveal his HIV Property 224 status, but admitted to the property manager that he had dismal credit because He had recently devoted all of his resources to taking care of a lover who had died of AIDS. Nithamer, however, offered to prepay 1 year's rent. Brenneman Properties rejected Nithamer's application and, in turn, Nithamer sued under the FHA. Does he have a case? See Nithamer v. Brenneman Property Services, Inc., 81F Sup 2D1, DDC 1999. 2. Over the phone, landlord said to plaintiff, "Do you have children? I don't want any little boys because they'll mess up the house and nobody would be here to watch them. Really, this house isn't good for kids because it's right next to a main road." Plaintiff sues. Landlord argues that her statements only show that she is concerned about the welfare of children. Is that a legitimate non-discriminatory reason to refuse to rent? 3. A local government has decided to knock down 2 high-rise public housing projects within its borders. The high-rises primarily house recent immigrants from Guatemala. A local advocacy group brings a lawsuit on their behalf, claiming that the government action has a disparate impact on a protected group. Is this a disparate treatment or disparate impact case? Can you think of a non-discriminatory reason why the government may have taken such an action? 4. The FHA requires landlords to make reasonable accommodations for individuals with handicaps. Which of the following requests by a tenant would qualify as a reasonable accommodation? A. Asking a landlord with a first come forward/first served parking policy to create a reserved parking space for a tenant who has difficulty walking. B. Requesting that a landlord waive parking fees for a disabled tenant's home health care aid. C. Asking the landlord to make an exception to the building's no pets rule for a tenant with a service animal. D. Requesting landlord to pay for a sign language interpreter for a deaf individual during the application process. E. Asking the landlord to provide oral reminders to pay the rent for a tenant with documented short-term memory loss. Chapter 8, Leasing Real Property 225. An exercise in advertising. Imagine that you are a lawyer for a newspaper in a large metropolitan area. The local chapter of the ACLU has raised concerns that some advertisements in the classifieds section of your paper violate the Fair Housing Act. 2. Your boss has asked you to review the ads for any offending language. Which of the following would you feel comfortable printing? 3. 2. Would any of these ads violate the Civil Rights Act of 1866? 3. The government does provide some guidance to landlords worried about triggering FHA liability through their advertisements. There are, for example, published lists of words to avoid and acceptable language. Although context is important, landlords can generally use these phrases: good neighborhood, secluded setting, single family home, quality construction, near public transportation, near places of worship, and assistance animals only. Property 226. What about this ad for a roommate on Craigslist? Is it objectionable to you? Does it violate the FHA? Does it matter that the poster is looking for a roommate? Would your answers change if the advertisement read, "Have a room available for an able-bodied white man with no children"? Fair Housing Council of San Fernando Valley v. Roommate.com, LLC. 666 F.3D 1216, 9th Sir 2012. Kaczynski, Chief Judge. There's no place like home. In the privacy of your own home, you can take off your coat, kick off your shoes, let your guard down and be completely yourself. While we usually share our homes only with friends and family, sometimes we need to take in a stranger to help pay the rent. When that happens, can the government limit whom we choose? Specifically, do the anti-discrimination provisions of the Fair Housing Act, FHA, extend to the selection of roommates? Roommate.com, LLC, Roommate, operates an internet-based business that helps roommates find each other. Roommate's website receives over 40,000 visits a day and roughly 1 million new postings for roommates are created each year. When users sign up, they must create a profile by answering a series of questions about their sex, sexual orientation and whether children will be living with them. An open-ended additional comments section lets users include information not prompted by the questionnaire. Users are asked to list their preferences for roommate characteristics, including sex, sexual orientation and familial status. Based on the profiles and preferences, Roommate matches users and provides them a list of housing seekers or available rooms meeting their criteria. Users can also search available listings based on roommate characteristics. Chapter 8, Leasing Real Property 227. Including sex, sexual orientation and familial status. The Fair Housing Councils of San Fernando Valley and San Diego, FHCs, sued roommate in federal court, alleging that the website's questions requiring disclosure of sex, sexual orientation and familial status, and its sorting, steering and matching of users based on those characteristics, violate the Fair Housing Act, FHA, 42 U.S.C. 3601. It seek analysis. If the FHA extends to shared living situations, it's quite clear that what roommate does amounts to a violation. The pivotal question is whether the FHA applies to roommates. The FHA prohibits discrimination on the basis of race, color, religion, sex, familial status, or national origin in the sale or rental of a dwelling. 42 U.S.C. 3604, b. Emphasis added. The FHA also makes it illegal to make, print, or publish, or cause to be made, printed, or published any notice, statement, or advertisement, with respect to the sale or rental of a dwelling that indicates any preference, limitation, or discrimination based on race, color, religion, sex, handicap, familial status, or national origin, or an intention to make any such preference, limitation, or discrimination.